Hello guys and welcome back to my no video. So in today's video I will be discussing section 22 of the Specific Relief Act. The marginal heading of the same is power to grant relief for possession, partition, refund of earnest money, etc. So this is a provision which is specifically for immovable properties as earnest money. In Hindi we might call it bayana, in English we might call it advance money. The advance money which is given at the time of buying an immovable property, something in the nature of a booking amount. And partition is the division of a property. Possession is possession as we all know it. So I have given a brief on these terms. Now let's move forward. Notwithstanding anything to the contrary contained in the CPC, any person suing for the specific performance of a contract for the transfer of immovable property. Immovable property, this section is applicable only upon the same, may in an appropriate case ask for possession or partition and separate possession of the property in addition to such performance. So this means that you might be seeking the specific performance of a contract, and if you are seeking the same, you are not precluded, you are not barred from, you are not prevented from seeking these reliefs also. So just to clarify, such sections like section 22 or even the explanation to section 21 which we had discussed in the last video, they are included in the statute to make certain things clear which are already clear. What I mean to say is that often confusions might occur if such obvious things are not mentioned in the text. If they are not mentioned, then the party who might benefit from the absence of such laws take advantage of it, and that would be injustice to the other party. So such clauses are included just as to make things clear. Also, if a suit has many reliefs being claimed in it, then it is a more comprehensive suit, right? And civil law is all about making suits as comprehensive as possible and promoting the ultimate disposal of the controversy between the parties. We would not want that any aspect of any controversy between the parties is left. So more the reliefs being claimed, the better it is. However, there are certain reliefs which might contradict each other or which can't be claimed together, but that is obviously not the subject matter of this section. I hope I have explained well the logic behind the same. Any other relief to which he may be entitled, including the refund of any earnest money or the deposit paid or made by him, in case of his claim for specific performance is refused. See, if the claim is refused, then obviously the other party can't be allowed to be benefited from such a breach. And so if any earnest amount, if any booking amount, etc. is paid, then the opposite party, that is the party who has breached the contract, will have to pay it back. Clause 2. No relief under clause A or B of subsection 1 shall be granted by the court unless it has been specifically claimed. As I mentioned in my last video, court will not grant any such relief which you have not claimed, provided that where the plaintiff has not claimed any such relief in the plaint, the court shall at any stage of the proceeding allow him to amend the plaint. Order 6 Rule 17 CPC, guys, on such terms as may be just for including a claim for such relief. So if it is being asked for, the amendment is being asked for at a initial stage, so the court might not impose any strict conditions or cost. But if it as a later stage, if a lot of time has passed on and it might be detrimental to the defendant's case on merits, so certain conditions or costs might be imposed, and that is very much justified also. Clause 3. The power of the court to grant relief under clause B of subsection 1 shall be without prejudice to its powers to award compensation under section 21. As I mentioned earlier, reliefs, if claimed together, are very much allowed, even promoted and appreciated, because it will reduce further litigation. Also, in such case, since if suppose you claim only one relief and then you file another suit in future with respect to the same subject matter property seeking new relief. So order 2 rule 2 of CPC might come into play. Order 2 rule 2 CPC in simple language says that you cannot be filing multiple suits and seeking different reliefs in same with respect to a particular subject matter. Say if you have a house, this section is about an immovable property, so I'll take an example of that. Suppose there's a house and the person first files a suit for his possession, then a separate suit for its refund of earnest money, then a separate suit for specific performance. So this activity isn't allowed because of order 2 rule 2. So I have completed section 22 of SRA also, and I hope you have liked my video and you all will appreciate the same also. Thank you so much.